Hello guys, I'm Shreya and I welcome you all to my channel Knowledge Info. Today in this video we will be talking about amendment of the Constitution, which is given under Article 368 of the Constitution. So basically, today in this video I will be discussing about Article 368 of the Indian Constitution. We will talk about its meaning, necessity, procedure and types and lots more. So without any further delay and blabbering, let's move towards our video. First, we will be discussing about the meaning of the amendment. It refers to the formal change in the text of the written constitution of a nation or a state. It is highly required in order to fix the loopholes of the constitution. It basically means an addition or alteration made to a constitution, statute, or legislative bill or resolution. Before discussing about the types and procedure of amendment, we need to know about one of the most important feature of the Indian Constitution, which is that it is the blend of rigidity and flexibility. Before understanding this feature of the Constitution, we need to know that based on this feature, our Constitution is divided into two types. One is rigid Constitution and the other one is flexible Constitution. Rigid constitution is that constitution which cannot be changed in the same manner as ordinary laws. It means that it is very difficult to be changed. In general sense, it is a constitution that is difficult or slow to change, usually because of a prescribed process of amendment that is detailed and lengthy in execution. For example, the American Constitution. Flexible constitution is that constitution which can be changed in the same manner as ordinary laws, which means that flexible constitution can be changed by a simple majority, whereas to change the rigid constitution, special majority is required. In general sense, a constitution that may be amended by the ordinary process of legislation and is therefore relatively easy to amend, for example, the British Constitution. It means that if we want to refer to the rigid constitution, we can refer to the American Constitution because it is one of the first longest written rigid constitution of the world. And if we want to refer to the flexible constitution, we can refer to the British Constitution or the Constitution of England. Based on this, we can say that our Indian Constitution has some of the provisions which can be amended easily and some are amended by following a difficult process of amendment. Therefore, it can be said that our Indian Constitution is a blend of rigidity and flexibility. Now we will be talking about the necessity of amendment, that why our Indian Constitution makers felt that there should be the amendment of the Constitution. Constitution need to be amended over time to adjust provisions that are inadequate in order to respond to new needs and in order to modify and guide the Constitution to reflect the reality of life and meet the demands of the time and situations arising in the country. It means that our Constitution needs to be amended in order to move with the standards of society. If the Constitution will not be amended according to the needs and demands of the society, then it will not be able to fulfill its core demand, which is to serve its citizens to the fullest. Now we will be talking about that which authority has the power to amend the Constitution. Basically, we will be talking about the power of amendment. Article 368 in Part 20 of the Constitution deals with the powers of Parliament to amend the Constitution and its procedure. It means that only the Parliament is the legislative authority who has the power of amendment, and no other legislative authority has the power of amendment. The Constitution cannot be amended by the state legislatures. Parliament can amend the Constitution by way of addition, variation, or repeal any provision of the Constitution. It means that Parliament has the authority to amend the Constitution by way of adding, by way of removing, or by way of changing any provision of the Constitution. But it is subject to the only restriction that the Parliament cannot amend those provisions which form the basic structure or values of the Constitution, which means that it cannot amend those provisions which affects or destroys the basic foundation of the Constitution. It was ruled by the Supreme Court in the Kesav Nanda Bharti case 1973. It means that Parliament can amend all the parts of the Constitution, but it is subject to the only restriction that Parliament cannot amend those parts of the Constitution which affects the basic value of the Constitution, which changes the nature of the constitution. The nature of the constitution is to serve the Indian citizens and to protect their needs and demands. Therefore, if the parliament will amend those features of the constitution which affect the values of the constitution, then the basic structure of the constitution will be affected and destroyed. And it was ruled by the Supreme Court in the case of Nanda Bharti versus State of Kerala case 1973. Now we will be talking about the procedure of the amendment, that how an amendment bill becomes an amendment act. The procedure as per Article 368 is as follows. The introduction of a bill in either House of Parliament and not in state legislatures. It means that the Constitution Amendment Bill can be introduced in either House of the Parliament. That is, it can be introduced either in Lok Sabha or in Rajya Sabha and not in state legislatures. Then the second step, that the bill can be introduced by either a minister or a private member and without the prior permission of the President. It means that a bill can be introduced by a minister or a private member and without the prior permission of the President. Unlike the money bill, the prior permission of the President is not required in the case of Constitution Amendment Bill. Third step, the bill must be passed in each house by special majority. That is 2/3 of the members present and voting and not less than 50% of total strength. Fourth step, each house must pass the bill separately and there is no provision for joint sitting. It means that the bill must be passed by Lok Sabha and Rajya Sabha separately and there is no provision for joint sitting, which means that the President cannot call both the houses for joint sitting in case of disagreement between both the houses. And it is kept as such by the constitution makers so that it doesn't affect the supremacy of both the houses while passing the Constitution Amendment Bill, because it is a very serious matter which is related to the amendment of the constitution, and our constitution makers wanted that the decision of both the houses should not be influenced by either of the house. Step number 5. If the bill is related to the amendment of the federal provisions of the constitution, it must also be ratified by half of the state legislatures by a simple majority, that is majority of the members present and voting. It means that if the bill is related to the amendment of the state provisions, that it must get the consent of the states while passing such a bill by simple majority, which means majority of the members present and voting. For example, if there are 300 members present out of 545 members of the Lok Sabha, then the consent of 50% plus 1 members is needed to pass such bill. It means if 151 members will give their consent in favor of the bill, then the bill is deemed to be passed. Step number 6. After being passed by both the houses and ratification wherever necessary, the bill is presented to the President for his assent. It means that after the bill is being passed by Lok Sabha and Rajya Sabha and ratified wherever necessary by the states, the bill is being presented to the President for his assent. Step number 7. The President must give the assent to the bill. He can neither withhold nor return the bill for reconsideration of the Parliament. It means that like money bill, the President has no right to reserve the bill with him or to return back the bill for reconsideration to the Parliament. It is obligatory for the President to give his assent to the bill. Step number 8. After the assent, the bill becomes an act. It means that after the President gives his assent to the bill becomes the Constitution Amendment Act. And it is being said that the Constitution stands amended in accordance with the terms of the Act. Now, let us discuss the types of amendment. Our Constitution can be amended in 3 ways. First is amendment by simple majority of the Parliament. Second is amendment by special majority of the Parliament. And the third is amendment by special majority of the Parliament and the ratification of half of the state legislatures. These are the 3 ways in which our Constitution can be amended. We will discuss all these 3 ways in detail, and we will be talking about the provisions in the Constitution which can be amended by simple majority, special majority under Article 368, and special majority and the ratification of half of the state legislatures. Let's begin. Which is amendment by simple majority, which means majority of the members of each house present and voting. For example, If there are 545 members in the Lok Sabha, out of which 300 were present at the time of voting, and out of 300 members, if 150 plus 1 members gave their consent, then the bill is deemed to be passed by simple majority. It means that more than half of the strength of both the houses, that is Lok Sabha and Raj Sabha, must give their assent in favor of the bill, and then the bill is deemed to be passed by the simple majority. Now let's talk about the provisions which are given under the Constitution which can be amended by a simple majority. Amendments related to citizenship, that who should get the citizenship and who should not be given the citizenship and based on what criteria. Amendments related to creation or removal of legislative council. Amendments relating to changing name or border of states. Amendments in Schedule 2 of the Indian Constitution, which talks about the emoluments, allowances of president, vice president, governor, etc. Amendments relating to change in the quorum. Quorum is the minimum number of strength of the members which is required to conduct the proceedings of the Lok Sabha. Sixth is amendments in rules and procedure in the parliament. It means that if the parliament wants to change its rules and procedure, then it can be changed by a simple majority. Now we will be discussing amendment within the scope of Article 368, which is amending power of the Parliament. Amendment by special majority under Article 368, which means majority of the total membership of the House and a majority of 2/3 members of the House present and voting under Article 368. For example, there are 545 members in the Lok Sabha, out of which 351 members were present at the time of voting, out of which 311 members gave their vote in favor of the bill, and 40 members didn't give their consent in favor of the bill. Now, let's calculate 2/3 of 351 members which were present at the time of voting, which is equals to 234 members. It means at least 234 members must give their consent in order to pass the bill. As per the above example, 311 members gave their consent in favor of the bill. Therefore, this condition is satisfied because 311 is more than 234 members. The second condition is that there must be consent of 50% plus 1 of the total membership of the Lok Sabha. That is more than 50% of 545 members of Lok Sabha, which is about 272, and that must be more than the members present and voting. As per the above example, value of the members present and voting, that is 311, is more than 272. Therefore, the second condition is also satisfied and the bill is deemed to be passed. It means that the bill will be passed by special majority under Article 368 if there will be 2/3 members of the House present and voting, gave their consent in favor of the bill, and it should be more than 50% plus 1 majority of the House, total membership of the House. Let's discuss about the provisions which can be amended by special majority under Article 368, which is amendments in fundamental rights, which means that the fundamental rights can be added or subtracted from the Constitution by using special majority under Article 368 of the Parliament. As was done earlier, when fundamental right of right to education till 14 years was added under Article 21A of the Constitution and right to property was removed. The amendments related to directive principles of state policy can also be made by using special majority under Article 368, and all other provisions which are not covered by the first and third categories, which means that those provisions which cannot be amended by simple majority and the special majority and the ratification of half of the state legislatures, then it will be amended by special majority under Article 368 of the Indian Constitution. At last, the third way to amend the Indian Constitution by way of special majority and ratification of states, which means the consent of the states, which means special majority of parliament and also through the ratification of half of the state by a simple majority. For example, there are 545 members in the Lok Sabha and the bill is passed by special majority as described above. Along with that, the bill will be sent to all the states for their consent. And if more than 50% of the states, that is out of 28 states, if the bill is passed by more than 15 states by simple majority, then the bill is deemed to be passed. which means that the consent of half of the states is required to pass the bill along with the special majority of the parliament, as was discussed in the second case of amendment. That if the parliament will pass the bill by using the special majority under article 368 and the consent of more than 50% of the states will be given in favor of the bill, then the bill is deemed to be passed by special majority and ratification of states. Now, we will be discussing about the provisions which can be amended by special majority and ratification by the states, which means that the ratification or consent of the states will not be required until and unless the powers of the states are being affected, which is that changes in executive powers between center and states, which means changement in the matters of state list or center list. Until these will be affected, the state's consent will not be required. Election of president and its manner and procedure. As states do participate in the process of the election of president, their consent will be required when there is any changement in the manner and procedure of the election of the president. Changes in legislative powers between center and states, representation of states in legislature, and the last, the power of constitution to amend the constitution under article 368 itself. It means that if the article 368 itself has to be amended, then it can be amended by a special majority and the ratification by the states, which is considered as one of the most rigid procedure of the amendment of the constitution. Therefore, with the help of these types of amendments, it is crystal clear that some provisions of our constitution can be amended by following a simple process of amendment, that is by simple majority, and some provisions are amended by following a rigid procedure, that is by special majority under article 368 and special majority with ratification by the states. So it is clearly being proved that our Indian constitution is a blend of flexibility and rigidity. Now, let us discuss about some important amendments which were made in the history of the Constitution. Some important amendments which have been made in the Constitution in its history are as follows. Number 1. Amendments which are made in relation to states, that is to include or make changes in the states. Amendments related to this category is 7th Amendment, related to reorganization of states based on linguistic basis or the language basis. Number 2 is 10th and 12th Amendment, through which Dadra and Nagar Haveli, Goa, Daman and Diu were added to India from Portugal. 13th Amendment, through which state of Nagaland formed with special protection under Article 371A. 14th Amendment, through which Pondicherry was included in Indian Union from France. 36th Amendment, through which Sikkim was included as Indian state. Now let us discuss the second category, amendments which are made in accordance to changes in the official languages. Amendments related to this category are 21st Amendment, which included Sindhi as an official language. 71st included Konkani, Manipuri and Nepali languages as the official language. And 92nd Amendment included Bodo, Dogri, Santhali and Maithili as official languages in our Indian Constitution. Other important amendments include 38th Constitutional Amendment, through which emergency declared by the President or Governor cannot be questioned by law. 39th Amendment, through which election of President, Vice President, Prime Minister, Lok Sabha Speaker kept out of judicial review. In general sense, if we try to analyze the impact of both these amendments, then we will understand that both these amendments restricted the powers of the court. Then other important amendment is 42nd Amendment Act 1976, which is also known as the mini constitution, because most widespread changes were made into the Indian Constitution through this amendment, which was made during the internal emergency during the time of Indira Gandhi. Under this amendment, fundamental duties were added to the Constitution of India. The words socialist, secular and integrity were added to the preamble. The next is 44th Amendment Act 1978, which was basically made to repeal the changes which were made in 42nd Constitutional Amendment Act to make our constitution more democratic. Under this amendment, right to property, which is included under Article 31 of the Indian Constitution, was removed from fundamental right and was made a legal right. In Article 352, to proclaim national emergency, internal disturbance was renamed as armed rebellion. As we know that national emergency can be declared by the President of India on grounds of external aggression, war and armed rebellion, in which the word armed rebellion was previously used as internal disturbance, which was renamed as armed rebellion after the 44th Amendment Act of 1978. President became empowered to send back the bill for reconsideration to the Parliament. Courts have been restored their powers to decide disputes on election. 52nd Amendment Act 1985, through which anti-defection law was passed in 1985, and 10th schedule was added in the constitution, which provided for the disqualification of the members of parliament and state legislatures on the ground of defection. The next is 61st Amendment 1989, through which voting age was reduced from 21 years to 18 years. Then the 73rd and 74th Amendment Act 1993, through which Schedule 11, which is related to Panchayati Raj system, and Schedule 12, which is related to municipal corporation, was added to the Indian Constitution. The next is 86th Amendment Act 2002, through which right to education was added as a fundamental right under Article 21A. 97th Amendment Act 2012, through which constitutional status was granted to cooperative societies, and Part 9B was inserted, which specified several conditions for state laws relating to cooperative societies. 101st Amendment 2016, through which power was provided to levy tax on both the union and state government by its union list and state list. Basically, it introduced the system of one nation, one tax. Basically, this amendment brought the introduction of GST to our Indian Constitution. 103rd Amendment 2019, through which 10% reservation was brought for economically weaker sections, which is known as the EWS category, and other than OBC, SC and ST, for admission to central government and private educational institutions and recruitment in central government jobs. So with this, we ends up with our video. If you have any suggestions regarding my video, do let me know in the comment box section. And if you liked my efforts which I tried to pour in this video, do like, share and subscribe to my channel. Don't forget to press the bell icon parallel to the subscribe button in order to get notified when I will upload my further videos. So it's the time to leave now. So until we meet again, stay home, stay safe, do take care of yourselves, do take care of your families, and there's a goodbye. Thanks for watching.